Good evening. And for all you young lawyers out there, your chairs actually can turn around. And there's no point. I'm going to be talking for the next 45 minutes. Make yourself comfortable. But it's good to be with you. As we all know Ben Franklin's comment that there's only two things in life that are certain, death and taxes. But since Ben's time, I think we've added one more area of certainty, and that is the certainty of America's enduring love affair with Abraham Lincoln. Because the power of his words and deeds are so timeless that his legacy just keeps getting stronger. Whether we're reading Doris Kearns Goodwin's Team of Rivals or watching Daniel Day-Lewis's Oscar-winning performance, Abraham Lincoln lives on in the American consciousness in a state of high regard. Therefore, what? How is that relevant to the Salmon P. Chase Inns of Court lawyers and law students in February 2015? Lincoln's popularity for the 150 years since his death provides you, me, and everybody in our profession with a golden opportunity. Because Abraham Lincoln, our greatest president, in fact, our greatest American hero, led our country through its greatest crisis, the Civil War, using the tools in the lawyer's toolkit. And therefore, contrary to the grumblings of the great unwashed, great lawyers matter in our society. My premise about Lincoln's being a great president because he was a great lawyer got confirmed by a very reliable source 6 years ago. On February 12, 2009, which was Abraham Lincoln's 200th birthday, I was with Pulitzer Prize-winning Civil War historian James McPherson, who spoke that day in Dallas about his then newest book, Tried by War, Abraham Lincoln as Commander-in-Chief. And when he finished his speech, I asked him, could Abe Lincoln have done all that he did as president if he wasn't a consummate lawyer? Dr. McPherson, who's a history professor at Princeton, has no skin in the game as far as the legal profession is concerned, said absolutely not. There is no way Lincoln could have persevered through the Civil War and done all that he did and called the shots that he did unless he had been a first-class lawyer. Tonight, as Candace mentioned, I'm going to speak on the subject, what lawyers can learn about professionalism and communication from Abraham Lincoln. And to the extent you decide to use Lincoln's pointers on professionalism and communication, that is, should you decide to use what you're going to be hearing about tonight in your own practice, then you will become an Abraham Lincoln kind of lawyer. Which means, number one, you'll always take the high road as a professional as you go about your business and dealings with others, which is exactly what was just read in your creed, taking the high road. Number two, you'll be clear, concise, and persuasive when you speak and when you write, capable of changing hearts and minds regardless of who's in your audience. And number three, you'll see your job as being the grease that helps lubricate society's essential machinery. On your tables are the handouts that I have for tonight's lecture. You see some excerpts from a book called Lincoln the Lawyer by Brian Dirks. And Brian Dirks was the father of this concept of Lincoln as the grease, the man who made it work, who made the society work smoother without friction. And as I read that and thought about it, it connected me with the epigraph in my book from William A. Rusher, Harvard Law School grad, who's the publisher of the National Review for many years. And particularly the law students, I want you to hear this tonight, and you're all going to get a copy of the book. This is at the beginning. By far the most useful and generally applicable variant of the species, however, is the lawyer. He is the lubricant of society's essential machinery. making sure as far as possible that its parts mesh rather than clash. Or to vary the metaphor, he is a sort of universal interpreter, making the words of one speaker intelligible to another. That was Abraham Lincoln. That's being the grease. That's making the business community work better, because you're helping to get deals closed, disputes resolved, so that people can get on about their business and go on down the road. And by embracing these objectives and adding them to your lawyer's toolkit, you'll become a lawyer who raises the bar in our profession. Now, before I go into Lincoln's lessons for us on professionalism and communication, I think you need to know something about his 23-year legal career so you can put all these lawyer lessons into context. And the specifics of Lincoln's legal career are found on pages 1 through 14 of the handout on your table. And I'm using two main sources. First is this Brian Dirks book, Lincoln the Lawyer. The second was a wonderful collection of essays that was in the Lincoln Bicentennial issue of the ABA Journal that Bill Robinson was involved with, that talks about the specifics of Lincoln's legal career. But here's what I've concluded from those as well as other sources. Because Lincoln's life and legal career are so well documented, archived, and preserved in the 17,000 books that had been written about him, as well as the Lincoln legal papers, 97,000 documents found at his presidential library in Springfield, Illinois, we know many things about Lincoln the lawyer. First, we know he was entirely self-taught. You want to learn a new word tonight, be able to go home and say, honey, I learned a new word. The word is autodidact. It means someone who is self-taught. They ought to put Abraham Lincoln's picture next to that word in Webster's dictionary. No one ever taught himself more than Lincoln. In his whole life, he had less than 1 year of formal schooling. That means he didn't go to high school, he didn't go to college, he didn't go to law school. As far as his legal career went, he had almost no mentoring. There was a senior lawyer in Springfield named John Stewart who allowed Lincoln to borrow his books, his law books, such that Lincoln's legal education came largely from spending 4 years reading Blackstone and other legal treatises by himself. People would ask him, well, when you were aspiring to become a lawyer, who did you study with? And his answer was the same. I studied with nobody, entirely self-taught. Because Lincoln gained admission to the practice of law at a time when getting licensed entailed only having a practicing lawyer certify that, number one, the applicant had completed the rudimentary training, and number two, he was of good moral character. Don't you law students wish that that's all you had to do today to become a lawyer? Second, besides the fact that he was self-taught, that throughout his legal career, Lincoln the lawyer worked his tail off. In the middle of his career, a young lawyer came up to him and said, what's the secret to practicing law? He said, it's very simple. The secret to practicing law is work, work, work. Period. The end. In his 23-year legal career from the Lincoln legal papers, we know that he and his partner handled over 5,000 matters and got over 1,000 verdicts in jury trials and argued over 400 cases to the Illinois Supreme Court. Now, to stay busy 12 months out of the year, he traveled the circuit because he had to. Springfield's population in the 1840s and the 1850s, when Lincoln was practicing law, started at about 2,500 people, and over that time, 2 decades, it grew to 10,000. There were several lawyers in town. There simply wasn't enough legal work to keep anybody busy 12 months out of the year. And so you had to ride the circuit in order to generate income 12 months a year for your family. So the circuit was 13 counties around Springfield, which was a 10,000 square mile area, which roughly twice the size of the state of Connecticut. And so 6 months every year, he left his wife, he left his children, and he traveled the circuit in order to stay busy. We also know that Lincoln the lawyer was not some kind of legal idealist, some kind of pie-in-the-sky cosmic notion of justice. No, he was a gritty, nose-to-the-grindstone lawyer, meaning he was just like us. He took his cases as they came in. He represented his client's side regardless of the nature of the case. And that means he answered the lawyer's highest calling, which was to honestly and vigorously represent his client and let the court evaluate the morality of the parties' positions. Third, we know that Lincoln the lawyer was incredibly versatile. Those were not the times when we had the specialists that we have today. Such that in his career, Lincoln handled hundreds, if not thousands, of debtor-creditor cases. He handled patent cases, divorce cases, big railroad cases, 27 murder trials, and 85 slander suits, to give you an idea of the variety that he had in the cases that he handled. And then finally we know that Lincoln worked so hard as a lawyer in order to enhance his political capabilities. There's no doubt about it. From the time he was very young, long before he aspired to be a lawyer, Lincoln had his eye on the political horizon. He saw it as the only way that he could attempt to fulfill his life's driving ambition. And that was, at age 23, somebody said, "Lincoln, what's your ambition?" He said, "Every man is said to have his peculiar ambition. Whether it be true or not, I can say for myself that I have no other ambition so great as that of being truly esteemed by my fellow men, by rendering myself worthy of their esteem." His law partner, William Herndon, said his ambition was the little engine that knew no rest. He never was disconnected from this driving ambition. And so that little engine that never stopped was blowing its horn from a mindset that said, I want to do something so significant in my life that it will cause all my fellow men to recognize me as having done great deeds. Now, a legal career could help a political career in many ways, obviously by refining his talents as a full-time trial and appellate lawyer. Lincoln became a more compelling public speaker and advocate. But there were many other reasons that his legal work elevated his political skills. The 14-county legal arena where he worked trained Lincoln in human nature, mediation, quick absorption of facts, discerning assessments of alternatives, and developing the courage and the wisdom to make quick responses to often ambiguous choices that demanded decisive and irrevocable action. He needed all those skills in politics, and particularly as president during the Civil War. And because Lincoln had this splendid array of talents, of legal talents, along with a solid grasp of constitutional law, James McPherson had to recognize that Lincoln could never have been a great president and carried the country through the Civil War without having been a great lawyer. Now that you know something about the specifics of Lincoln's 23-year legal career, let's turn to the professionalism part of my speech. And my focus on Lincoln's legal ethics tonight will be entirely based on an essay he wrote sometime in the 1850s that he probably used to give a speech to young lawyers, perhaps law students, and it's called Notes for a Lecture on Law. It's on pages 15 and 16 of your handout. It was found years later, and it's the best, most concise statement of Lincoln's ethical perspective on being a practicing lawyer. And here are his points. First, diligence. Leave nothing for tomorrow which can be done today. Never let your correspondence fall behind. Whatever piece of business you have in hand, before stopping, do all the labor pertaining to it which can be done. Now, what does that mean in 2015? Never let your correspondence fall behind. Well, we all know, who are practicing every day, we don't send many letters anymore. It's all emails. But if you've ever talked to anybody involved in the legal malpractice business, they'll tell you that most of the complaints filed against lawyers have to do with their failure to return phone calls and respond to emails. So Lincoln may have been using the word correspondence, but it's absolutely timely. Be diligent. Stay on top of it. Don't fall behind in your communications with others. But then he said something that's even more important. Whatever piece of business you have in your hand, before stopping, do all the labor pertaining to it which can be done. Now, when I was a very young lawyer, I went to a seminar in Texas, and one of the guest speakers was a Supreme Court justice in Texas named Eugene Cook. And he said something that stayed with me. He said, "It is not the amount of time that a lawyer spends on a matter that counts. It's the amount of uninterrupted time that counts." And in 2015, with emails coming at you all the time, texts, phone calls, interruptions of any and every kind, when you've got to zero in on a client's problem, you better find a way to disconnect from all those distractions. That's the only way you can be diligent. That's exactly what Lincoln was saying in the 1850s. The second thing he said in these lectures to young lawyers, extemporaneous speaking should be practiced and cultivated. It is the lawyer's avenue to the public. But don't become so enamored of speech making that you claim an exemption from the drudgery of the law. Now, you law students and young lawyers, you may aspire to be commercial litigators, and I got bad news for you. We are living in the era of the vanishing trial. That's true in Texas, that's true everywhere in the country. There are fewer lawsuits being filed, there are fewer lawsuits being tried, and so if your goal is to wax eloquent in front of a jury, if the only practice you get is the occasional times you get in a courtroom, you're not going to be very good. And so Lincoln is saying extemporaneous speaking should be practiced and cultivated. How are you going to do that? You can teach a Sunday school class. You can speak to a Rotary Club. You can speak to the Inns of Court. You can speak at a bar convention. There's lots of speaking opportunities in the world. Use your imagination, get connected with groups, and find opportunities to get up and present to an audience. It's not only about what you do in the courtroom. If you're really good in front of an audience, you're going to be really good in a courtroom. But, as he says, don't become so enamored of speech making that you claim an exemption from the drudgery of the law. Bad news for you law students. A big part of what lawyers do is drudgery. It's unfortunate. When I got out of law school, about 2 years after I'd been out of law school, a guy in my class named Pete Guerin. And Pete later got tired of the law, became a member of Congress, and was United States Secretary of the Army under President Bush and early in President Obama's administration. But I saw Pete walking around downtown Dallas at lunch, and I said, "What are you doing?" He said, "Well, I'm sitting here, reviewing boxes and boxes and boxes of documents." And then he said, "You know what they really don't teach us in law school, and that is that there's something that separates lawyers from the rest of the human race, and that is we have a capacity to do boring things for longer periods of time than anybody else in society." It's bad news, but it's the truth. And if you can't handle it, if you can't deal with it, if you think you're too cool for drudgery and grinding it out, then you're not going to be a successful lawyer. Sad but true. The next thing he said, discourage litigation. Now here's Lincoln. He's a trial lawyer. He's an appellate lawyer. And he's telling all the young lawyers, discourage litigation. Persuade neighbors to compromise whenever you can. Point out the nominal winner is often a loser in fees, expenses, and waste of time. By being a peacemaker, the lawyer becomes a better man. There will still be business enough. That's the grease. That is the social machinery. You don't have to practice law very long before realizing that the parties who are actually involved in the lawsuits, who are paying the legal fees, hate every minute of it. They go to bed at night anxious. They hate it when the monthly fee statement comes in because it's expensive, it drags on, it takes the people in their business, they've got to take time producing documents, giving depositions. They hate it. And that's why Lincoln said, discourage litigation. Find the prompt settlement. Now, you can't always get it, but at least if you're trying to get to the goal line, that's what your client wants. And so be mindful of that objective. And then he says, a related point, never stir up litigation. Don't create lawsuits where they don't now exist. Well, in Lincoln's time, the way people stirred up litigation was they'd go to the real estate records and they'd see where they spotted maybe a title defect. And in fact, Lincoln's moved from Kentucky to Indiana to Illinois because his father kept putting the family log cabin on properties where he didn't have good title. He was always in court because of these title defects. And so lawyers who didn't have enough to do would go down to the county records and come up with a lawsuit. Trespass to try title. Well, we still have those today, but we have other situations where lawyers are trying to stir up litigation. That's what too many class action cases are all about. We read too many times of these massive settlements where the members of the class get pennies and the lawyers get millions. And that's what fuels the lawyer jokes and the demise of the reputation of our profession. Then Lincoln talked about the matter of fees. An exorbitant fee should never be claimed. And don't take your whole fee in advance, nor any more than a small retainer, because if you do, you'll lack interest in the case, and therefore you will lack skill and diligence in performance. Now, those of us at large law firms, mine has 350 lawyers, we like big retainers. But you can't set the fee arrangement in a way that you're not incentivized to stay hungry toward getting to the most efficient, satisfactory goal line of resolution for your client. If you aren't, and money talks. So he's saying make sure your fee agreements incentivize you to stay diligent and engaged. And then last but not least, in these points on professionalism, he says, resolve to be honest in all events. Lincoln famously said, no one has a good enough memory to be a successful liar. Nobody's that good. And the thing that separated Lincoln from too many of the people in the profession, he wasn't just talking about honesty. He's talking about intellectual honesty. And you young lawyers might say, what in the heck are you talking about, intellectual honesty? Well, here's what I'm talking about. When the time comes for you to go argue a hearing in a trial court, or maybe the time comes for you to argue to a court of appeals or a Supreme Court, too many lawyers, in making their argument, misrepresent what their opponent has said. They think that's smart. They think that gives them a chance to win by misrepresenting the arguments made, the citations that they're citing. And all they're doing is making themselves look bad, making themselves look like they are not credible, because the judge knows when something is being misrepresented. And so that's the final and key point on the professionalism. Don't just be honest, be intellectually honest. During the Lincoln-Douglas debates, it really ticked Stephen Douglas off that Lincoln would get in front of the crowd and exactly state what Douglas's arguments were. And then he'd show why Lincoln's were better. But it wasn't because he was misrepresenting what Douglas was saying. He nailed it. But then he explained why what he was saying was better. That's the way you want to make your legal arguments. All right, so based on the vast historical records that we have in the Lincoln legal papers, do we have enough history to know, can we grade Abe Lincoln's walk compared to his talk? We know what his talk was. We know what these professionalism points he's trying to tell the young lawyers. Did he practice what he preached? Well, in fact, you can look on page 18 of your handout. Was he diligent? You bet he was diligent. He worked long hours, over 3 jury trials every month for 23 years. 1.5 Illinois Supreme Court arguments per month for 23 years. He rode the Illinois circuit 6 months out of every year, leaving his family behind. He took work as it came in the door, even if it meant being on both sides of an issue. He handled 133 cases involving railroads. In 71 cases, he represented the railroad company. In 62 cases, he represented the party on the other side of the railroad company. He knew all the authorities when it came time to argue. He was the embodiment of what former Secretary of State James Baker calls the 5 Ps. You young lawyers, if you don't remember one thing I say tonight except this, remember the 5 Ps. Proper preparation prevents poor performance. Lincoln got it. You need to get it. If you're not prepared, don't expect to be good. Next, did he cultivate his extemporaneous speaking outside of the courtroom? You bet he did. Obviously, politics. He's given speeches all the time. But wherever town he was, he participated in debating societies. He gave public lectures. He was always trying to get better in front of an audience. Did he discourage litigation? When the facts or law were on his side, people would famously come in his office, okay, Mr. Lincoln, here's my case, here's the facts. What do you think? And if he didn't like what he heard, if he didn't like the facts, if he knew how the law would apply the facts, he said, you need to go settle fast. He wasn't one of these guys, oh, here, let me represent you, maybe we can come with one. No, go settle. He filed no lawsuits unless he believed the facts and the law were on his side. He handled over 5,000 matters, 1,000 jury trials. Obviously, the substantial majority of the matters he handled, he settled. Did he refuse to stir up litigation? No, he wasn't digging around in the courthouse real estate records trying to find title defects. Did he charge a fair fee? Yes, he did. Here's a famous example. Lincoln and a guy named Ward Hill Layman handled a case on behalf of the conservator for his mentally challenged sister. A scoundrel, after her money, persuaded her to marry him and filed a petition to remove the conservator. Layman got a retainer from the conservator of $250. Lincoln presented the case on behalf of his client so forcefully, he got a favorable outcome from the judge in 20 minutes. He then told Layman, you need to give our client back half the fee. We did this too fast. He did also tell us in the area of fees that when a client defaults on your fee agreement, it's perfectly fine to sue for your fee. Lincoln did that a lot. And finally, was he intellectually honest? Here's something for you. In his opening statements, he would tell juries, if I falsify what I'm telling you now, you can convict me. I'm laying it down. I'm giving you the facts straight. And if you learn from the evidence you hear at trial that I was wrong, convict me. It was because of this steadfast intellectual honesty that from time to time, judges would get sick, judges would have to leave town. Their first choice, always to pinch hit and take the bench, was Abraham Lincoln. Now, having reviewed Lincoln's perspective on professionalism and his adherence to what he said in his essay, let's now go to the communication part of my presentation that begins on page 19 of your handout. And in that, I have 2 main sources. I don't want you to think I've just made this stuff up. But there's 2 main sources that are in your handout. A guy named David Acord wrote a book called What Would Lincoln Do? About how Lincoln, through his correspondence, demonstrated how he handled very tricky interpersonal situations. And in the second, Fred Kaplan, his book on Lincoln called Lincoln, Biography of a Writer, where he studied a vast quantity of Lincoln's writings. Now, all of us, as lawyers, are in the communications business. If we're not great communicators, we don't have a chance of being great lawyers. So how did Lincoln do it? What were the tools in his communications toolkit? Do each of us have access to these tools in our own communications? Well, that's why Bill Robinson brought me all the way from Dallas, Texas, so I could help answer these questions. Now, Lincoln had 6 primary tools that he used to be our country's greatest all-time communicator. First, Lincoln was obsessed with precision in his choice of words. Because like all great lawyers, Lincoln took his words seriously. The late Jacques Barzun, Dean of Columbia University, wrote an essay, Lincoln the Literary Artist, where he said, quote, "A part of Lincoln's extraordinary skill in communicating came from the practice of legal thought. The language of the law foresees doubt, ambiguity, confusion, error, and one by one it removes them. The great compression of Lincoln's language came after he had, lawyer-like, removed all unsatisfactory wording alternatives and hit upon just the right order and emphasis. I'll put this scholarly assessment of Lincoln's word precision power into 8 words. Say exactly what you mean. Eliminate all unnecessary words." As lawyers, we better take those words to heart. Why is word precision so important? Because with consummate word precision comes clarity. Fred Kaplan, Lincoln biographer, gives this vivid description of how clear Lincoln's communications were. Lincoln's words were like a perfectly focused camera image, like looking through 100 feet of clear water marked by transparent honesty. How Lincoln made his messages so clear was recognized by Douglas Wilson, another biographer, when he noted Lincoln's response to someone's ill-fated attempt at editing one of his speeches. Lincoln explained why he rejected the editor's suggestions as follows, quote, "I don't want the sense changed or modified to a hair's breadth. Mr. Editor, you, not having studied the particular points as closely as I, cannot be quite as sure that you do not change the sense when you don't intend it. For instance, in a note at the bottom of the first page, you propose to substitute Democrats for Douglas. But what I'm saying here is true of Douglas, but not of all Democrats, such that your proposed substitution would be a very considerable blunder." Here Lincoln was making the points, in my speeches, my words say exactly what they mean. Lincoln went on in his response to the editor. On page 5, your proposed insertion of the word residences, though it would do little or no harm, is not at all necessary to the point I'm trying to make. Here Lincoln was saying, in my speeches, I will not allow one needless word. In fact, Lincoln was maniacal in condensing his communications into the fewest possible words. His was a telegram composing mindset. You know how telegrams work. The shorter, the less costly, the better, so long as the message is clear. Here's an example of Lincoln's giving maximum information with minimum words in the opening statement in one of his jury trials. Quote, "Turn then to that horror-striking scene at St. Louis. Only a single victim was sacrificed there. His story is very short and may be the most highly tragic of anything of its length that has ever been witnessed in real life. A mulatto man named McIntosh was seized in a city street, dragged to the suburbs, chained to a tree, and actually burned to death, and all within a single hour from the time he had been a free man, attending to his own business and at peace with the world." Now, how's that for precision and clarity? A complete, heartbreaking story in 4 tight sentences. Second Lincoln communication tool, his acute sense of audience. With this sense, Lincoln could speak his listeners' language and thus could better empathize with them, which put him in a position to touch their hearts.
And once he did that, he could change their minds. He knew, and lawyers need to know, you can't think about changing a person's mind without first changing his heart. Now, here are some examples of Lincoln's versatility using different types of language with different types of audiences, which allowed him to maximize his message in front of every single crowd he addressed. When Lincoln got in front of juries, who were then made up mainly of farmers and people with limited education, he used his down-home, common folk touch. Harriet Beecher Stowe said Lincoln's words had the relish and smack of the soil. He once told a young lawyer how to talk to a jury. Don't shoot too high, shoot down low. Only then will the common people understand you. John Scott, a trial judge in many of Lincoln's trials, recognized that besides shooting down low, Lincoln also got juries going his way by staying in a mode of constant humility throughout a trial. Judge Scott said, an attorney makes a grave mistake if he puts too much of himself into his argument before the jury. In the cases he tried in my court, Lincoln kept himself in the background, seeking nothing more than to be an assistant counsel to the jury on whom the primary responsibility for the case rested. So whenever we talk to a jury, Lincoln instructs us to shoot low and stay humble. In his political speeches, Lincoln sometimes had to present to rooms filled with college-educated, upper-crust people. On those occasions, Lincoln knew to aim high, not shoot low. For example, at Cooper Union in February 1860, the speech that made him president, his audience was made up of New York City's political elites, the Republican Party leader, none of whom had ever met Lincoln before. They'd maybe heard of him because of the national publicity he had received from the Lincoln-Douglas debates in 1858, and they all came to see Lincoln in action at Cooper Union to determine whether he should be their candidate for president later that year. For them, Lincoln shot high, with a scholarly presentation filled with tightly organized facts gleaned from thorough research, resulting in compelling analysis. Knowing the horsepower of his audience, Lincoln did not use his jury touches of humor, anecdote, and the colloquial. The Cooper Union speech took 90 minutes to give. In it, master litigator Abraham Lincoln built his case to show that Stephen Douglas, who everyone thought was going to be the Democratic presidential candidate in 1860, was dead wrong when he claimed throughout their debates that our founding fathers intended for the issue of allowing or disallowing slavery in new states to be an issue determined by each new state's government and not by the federal government. Here's how Lincoln disproved Douglas's claim about states' rights and slavery at Cooper Union. He told the crowd that a grand total of 39 people had signed the Constitution. Of those 39, after the Constitutional Convention ended, 23 later served either in Congress or a state legislature and had had occasion to vote on the issue. 21 of the 23 founders had voted against slavery expansion determination being a matter of states' rights. And for the remaining 16 Constitution signers who didn't serve in legislatures and therefore never had occasion to vote on the issue, 15 out of the 16 in their speeches and letters left a clear record that they also believed that making decisions about slavery's expansion into new states was the federal government's responsibility. Thus, in his Cooper Union speech, Abraham Lincoln shot high and essentially examined and cross-examined the record of all 39 signers of the Constitution one by one and proved that 36 of them wanted the feds and not the states controlling the growth of slavery as the country grew. Showing that kind of analytical and oratory star power to the big dog Republicans at Cooper Union showed the crowd that he was the man most likely to beat Stephen Douglas in the November election. Another example of Lincoln's tailoring his communications to a specific audience was his Emancipation Proclamation, a purely legal document that Lincoln knew when he issued it was going to have to withstand an audience of United States Supreme Court justices. If you've ever read the proclamation, you know it reads like fine print boilerplate, like the documents you sign but don't read when you go in for surgery. There's no eloquence, there's no frills, it's just dry, technical verbiage that's legally airtight and therefore could pass muster with the Supreme Court. Now, the proclamation's language was purposely dry and tight for another reason, to influence another audience besides the Supreme Court. And that other group being the people who lived in Kentucky and the other border states. I hope each of you knows the statement that Lincoln wrote in a letter during the Civil War's first year. He said, quote, "I think to lose Kentucky is nearly the same as to lose the whole game. If Kentucky is gone, we cannot hold Missouri, nor, as I think, Maryland. With all these against us, the job on our hands would be too large for us." The Emancipation Proclamation did not free the slaves in the border states. It said it applied only to slaves in rebellious areas. Thus, the proclamation contained no volatile words to arouse emotions and specifically allowed the border states to retain slavery because Lincoln knew he had to keep those states on his side if he wanted to win the Civil War. Now, the final example of Lincoln's skill in matching his words to a particular audience came in his major addresses, where, in his own words, he aspired to be the right man using the right word to develop the latent fire and enthusiasm of the masses. He did this using potent language and few words, accentuating the premise, less is more, that applies then and now because every crowd in the history of the world, including the Salmon P. Chase Inns of Court, would rather hear a short speech than a long one. Now, here's how Lincoln explained to the masses in 3 sentences in November 1863 the context for his dedicating the National Cemetery at Gettysburg using language that was spare, colorful, and accessible to the masses. Quote, "In a larger sense, we cannot dedicate. We cannot consecrate. We cannot hallow this ground. The brave men, living and dead, who struggled here, they have consecrated it. Far above our poor power to add or detract. The world will little note nor long remember what we say here, but it can never forget what they did here." On the subject of less is more, the Gettysburg Address took only 3 minutes to deliver and contained only 275 words, which is about 1/3 the length of a normal newspaper editorial. And Lincoln's second inaugural address, the one that ends with malice toward none, with charity for all, and sought to heal the nation's wounds at the end of the Civil War, contained only 700 words, and of those, over 500 were one syllable. Now think of Lincoln's different audiences: small-town juries, big city political elites, the U.S. Supreme Court, the conflicted people in the border states, and the cross-section masses. Think of his different linguistic approaches to each of them. And think of the different types of people who each of us gets called on to communicate from time to time. Our job is to speak to them in a way that will resonate and penetrate. And to do that, we got to know who's in our audience, and we got to speak their language. Now, the third tool in Lincoln's communication arsenal: never misrepresent or overstate anything. That's the intellectual honesty point. Honest Abe Lincoln was wired for truth, not just from an integrity standpoint, but from a communication standpoint. He knew truth is essential to credibility, and credibility is lost when it is clear that a speaker is playing fast and loose with his facts. Brian Williams is the poster child for this rule of communication. Now, as I mentioned earlier in the professionalism part of my speech, Lincoln stood out from his contemporaries in the legal and the political arena because he always accurately stated his opponent's argument before rebutting it, and in his rebuttal he supported his position with indisputable facts to make sure he had maximum credibility, because credibility only comes from transparent intellectual honesty. So go slow and be tight with your facts, not fast and loose. Fourth tool, when it was time to persuade, Lincoln spoke with an impassioned and earnest tone that flowed from the sincerity of his convictions. One of his colleagues observed that when Lincoln got thoroughly roused, quote, he would come out with the earnestness of conviction, a power of argument, and a wealth of illustration that I have never seen surpassed. You saw Daniel Day-Lewis project Lincoln's earnest and impassioned tone and sincere convictions throughout the movie. Lincoln's political hero was Henry Clay. When Clay died, Lincoln gave a eulogy, and in it he identified the key to Clay's oratory power. And it also happened to be what Lincoln thought this is the way it ought to be whenever he took the podium. He said, Mr. Clay's eloquence did not consist in elegant arrangements of words and sentences, but rather of that deeply earnest and impassioned tone which can proceed only from great sincerity and the speaker's thorough conviction in the justice and importance of the cause, and that is what truly touches the chords of human sympathy. Note, however, this is big however, that an earnest, impassioned tone is not an emotional exhortation. Dr. Barzun points out in his essay that Lincoln never seemed to have considered it within his power to convince by disturbing others' judgment using his emotions. So when we're making our points, trying to persuade in front of a judge, jury, or any other group, we need to speak with an earnest tone that communicates our conviction without being emotional. Fifth tool, Lincoln built rapport with all his audiences using wit, but with calculated restraint. Here's an example of Lincoln's wry wit. As president, he often told the story of the time when he crossed paths with a senator when he was walking around Capitol Hill. During their brief conversation, the senator became irritated because of Lincoln's using a steady stream of humorous allusions which diverted the attention of the senator from trying to talk about what he wanted to talk about. And finally, the senator had enough. He said, Mr. President, I think you would have your joke if you were within a mile of hell. To which Lincoln replied, you know, you're right, Senator, and that's about the distance from here to the Capitol building. Now, wry wit and humor are good in building rapport whenever we're communicating with anyone, in a courtroom or anywhere else. Because judges and juries love any lawyer who can make them smile from time to time, but don't go for the belly laughs. You lose your power to persuade when they think you're trying to be a comedian. Now, Lincoln's sixth and final skill in his communications toolkit is my favorite. And it's a skill that too few lawyers and other speakers recognize. Barzun identified it. He said, when he encouraged those reading Lincoln's speeches, quote, let his choice of words, the rhythm and shape of his utterances linger in the ear. When you do that, you begin to feel as he did. His extraordinary power was to make his spirit felt. Many of you, like me, enjoy reading David McCulloch, John Adams, Truman, Mornings on Horseback, Theodore Roosevelt. And the reason you love him is because his words have such a great rhythm. I got to spend a day with David McCulloch 4 years ago, and I learned how he gets that rhythm. Every time he finishes writing a chapter, he reads it aloud to his wife. And they both have to be satisfied that the words have the right rhythm before he begins writing the next chapter. And to have a rhythm in one's delivery, a poet's sense of rhythm requires the man at the podium or the woman at the podium to speak slowly and pause at the right time to create emphasis on the key points. Now here's an example of Lincoln's language using the power of rhythmic repetition from the well-known conclusion to the Gettysburg Address. This nation, under God, shall have a new birth of freedom, and that government of the people, by the people, and for the people shall not perish from the earth. How's that for rhythm? To make a keynote speech's final words resonate, reverberate, and penetrate. Here's a more rhythmic prose that even rhymes from Lincoln's second inaugural address. Fondly do we hope, fervently do we pray, that this mighty scourge of war may speedily pass away. In those 4 short lines, Lincoln captured the entirety of what was front and center in the mindset of every person's mind in that Inauguration Day crowd on that day in March 1865, 1 month away from the surrender at Appomattox. So there they are, Lincoln's 6 communication tools: word precision, acute sense of audience, refusal to misrepresent or overstate, earnest but not emotional tone, calculated but not overdone wit, and rhythmic, deliberate cadence. Use all 6 and watch how your improved communications will enhance your leadership. You have on your tables these little cards. I brought enough for everybody. On one side are his 6 tools of communication, and the other is 6 precepts of professionalism. I hope you'll keep them in your pocket, in your wallet, and use them as a reminder of the things you heard tonight. I'll close with a quote from Ralph Waldo Emerson, recognized by most as America's most influential writer of the 19th century. And here was his evaluation of Lincoln as one word master paid tribute to another. Quote, "What pregnant definitions, what unerring common sense, what foresight, and on great occasions, what lofty and more than rational, what humane tone." Now, wouldn't we love it if somebody said that about our communications? Now, every journey begins with a single step. May you leave here tonight and tomorrow start to use Lincoln's high-powered tools in your communications and your professionalism so you can be even better lawyers. And as members of this fine Inns of Court, continue to take responsibility for raising the bar in this northern part of the great state of Kentucky. Thank you very much.
About you all, but I feel like I've learned a lot this evening. It's amazing how many years you could be a lawyer and not realize all the things about Lincoln that you shared with us tonight. So the one thing I do know, and I think most lawyers in this room know, is that Lincoln, of course, was famous for time is our stock in trade. And you have given very generously of yours, and we appreciate that very much. Thank you. Gift for you from your Kentucky Inn of Courts.
Oh, thank you.
Thank you. Thank you. And I'd also like to give a special shout out to Bill Robinson for making this happen, one of our founding members of our Chase Inn of Court. And Bill has also been very generous in gifting Mr. Boston's book, Raising the Bar, to all of our student members as well. So, Bill, thank you for that. Folks, the handouts actually, as most of you know, the handouts came to you electronically. So there are some copies on the table, and you're welcome to take any of the paper copies that you want. And of course, we have our cards, and appreciate that very much as well. So our meeting tonight then is concluded. I do want to just remind you of our March meeting. We've had a change in date for our March meeting. It will be on March the 24th, on Tuesday the 24th, and that will be set forth in the notice for you that's will be forthcoming. So unless anyone has any other announcements, anything else for the good of the order? All right, great. Well, thank you. Enjoy your evening. Thank you. Oh, I do have one more announcement. I'm sorry, folks. Out on the table with Karen are the order sheets for those of you who would like to take an order form to purchase Mr. Boston's books. Those are out on the table as well. Thank you so much. Thank you.